Good evening and welcome everybody to our Strata Committee training webinar this evening. We thank you so much for your time and logging on to hear all about safety, particularly on the common property and basically all of our obligations. Feel free to use the Q&A function. You'll see that at the top ribbon of your screen. So feel free to throw in any questions and we'll do our best to cover them either directly messaging you, or we'll throw a question probably to each other as we sort of go through the pertinent points. This session is being recorded. So those Strata Committee members you may know in your Strata scheme that were unable to make it to the webinar this evening, we will be sending around a copy of the recording to all who did attend and all who didn't attend. So just firstly, before I kick off, just to introduce who we are. So my name is Andrew Tunks. I'm the Learning and Development Director here at NetStrata. And I'm joined by James Moyer, our principal lawyer at Moyer's Law. Welcome, James. Thanks for your time this evening.
Thank you.
So if you don't know, NetStrata have a partial subsidiary called Moyer's Law. So Moyer's Law started, or actually commenced late in 2023 in December, and basically here to obviously provide legal services to our strata schemes and obviously the industry as a whole. So we welcome Moyer's Law obviously to our broader group of companies. Also, just to cover off a little bit of legalese here, so disclaimers, webinar is obviously for informational purposes only and should not be constructed or considered as legal advice. So if you do want specific legal advice, well, we've got a lawyer on screen here that is more than happy to help you out, or obviously consult the lawyer of your choice if there's anything that you, as I say, require specific advice on. And just before we kick it off, generally these webinars, I like to just explain that we do have a very big focus here at NetStrata on training, specifically our obviously our Strata team who have Certificate 4s in Strata Community Management. They obviously attend regular meetings. We've got a whole pile of different courses that we've developed internally, both in Strata and in trades basics, so things like plumbing, electrical, construction, building defects, etc. Strata Law, obviously part of James's role is obviously to keep our team abreast of legal changes, etc. And obviously this evening you'll no doubt benefit from that expertise. So yeah, I really do like to stress that we have a very high sort of focus on training our people. And we also have a very big focus in 2023 and 2024 in training our Strata Committee members. Now, I am also aware that the state government are looking at making Strata Committee training mandatory across the industry. So I think that's a positive step forward. And obviously, everyone that's logged on this evening sees the benefit in that, I hope. Also, if you have missed any previous Strata Committee training webinar, the email links that we send you to register, if you scroll all the way down to the bottom, you'll see an image like on the right-hand side of the screen there. You can simply click on those little images with the description of the topic, and that'll take you to the private YouTube channel where you can obviously view those recordings. Next, who are we? So if you're new to NetStrata or you possibly don't know our journey, we were established in 1996 in Hurstville and Carlton. So we've been around a long time. We also started NetStrata Wollongong in 2011. So we do have that regional branch there too. And we were large Strata Management Business of the Year in the years that you can see on the screen there, 2019, 20, 21, 22, 23. So we're obviously very, very proud of that. We're also been very busy in the software and accounting space. If you're unaware, we do have a NetStrata Space app. You can download that and see all sorts of things pertinent to your scheme. So things like your financials, where your levies are paid up to, etc. You can also notify strata managing agents of any issues around the building or bylaw breaches, etc. So if you want to scan the QR code, you can quickly do that on the screen here. I will have another slide towards the end of this webinar where you can also do that, or you can jump on our website and follow the links to the downloads page. What else have we been working on? Well, we've been inspecting our site. So hopefully you've received one of these reports on the left-hand side of your screen, which are our reports that our strata managers do when they go out and inspect your building and make suggestions and ensure the cleaning is up to standard and that sort of thing. We also, as I said before, we do have a big focus on training. We're about to obviously move into a new premises with larger meeting rooms and training rooms, which our team will benefit from greatly. So as I said, we we do have regular training sessions and make sure our strata managers are up to date with what they need to be up to date with. What else we've been working on? New schemes, existing schemes. So we do, specialise in all sorts of schemes, big, tall, community schemes, building management committees, all that sort of stuff. So if you've got any questions, obviously feel free to ask our staff. They would generally manage a large array of properties. Lots of meetings. So we actually, behind me now, there's a whole bunch of strata managers in the office doing strata management meetings. So we're very busy on that front, obviously arranging works. But what we're going to be talking about is partially arranging works. So we're going to be talking about essential safety obligations for strata committees, so navigating common property compliance in New South Wales. And we're going to be focusing on a couple of points here. So some recent legal cases which underline the importance of proactive safety management. And as we go through the webinar, you will pick up that there's a bit of a theme on making sure that works are done promptly. And obviously ensuring that the safety of occupants around the building is held at the highest standard. We'll explain what a PCBU is, so person conducting business or undertaking. We'll obviously take into account the legalese, and then point number 3, give you some guidance for strata committee members on what you can be doing. And also we'll finish off with some other areas to sort of focus on. So firstly, I'll just throw it out there. You can pop it in the Q&A if you like. But do you fully understand your obligations as a strata committee member with regards to safety on common property? So feel free to fire it in the Q&A or the chat. Not a problem there. Just interested to see your thoughts on that particular one. What have we got there? No, yep. So there's a couple of people honest there that potentially no, that's okay. Well, that's what we're here for. So you're in good hands. I'm not sure. Yep, not a problem. No. Okay, yeah, so an overwhelming I'm not sure or no. So that's exactly why we're here. And it's our job, obviously, to keep you informed and, ensure that we can, give you advice and protect you as much as possible. So with that, we're going to start with some recent case law. So there's a not so recent case here. I'll start with this one. So this was quite some time ago, but I thought it was sort of relevant to what we're talking about today. Now, this particular case back in 2013 involved an incident where there was a slip and fall on a wet driveway, and basically an owner held liable for not installing safety measures like handrails. So, in this particular one, obviously we think about the duty of care. So where we have had basically, incident reported that a driveway or whatnot is slippery. If we're doing nothing about that, then there's potential liability there. And obviously, in this particular case, there was a prosecution there. The next one here is, I'm going to bring James in on this one. And basically this one, Doherty versus the Owners Corporation, Strata Plan 36613. Now, this one was an interesting one. So non-compliant balcony balustrade height. So basically what happened here, there was an obligation to upgrade to current safety standards, highlighting the duty to maintain safe common property. So this one was an interesting one. I recall it was not too long ago when this came about. In Strata land, we've always thought that, a balcony balustrade, can be left alone unless you're renovating the building and you're replacing the balustrade, then you need to comply to today's standards. But in this particular case, they weren't necessarily intending on renovating or replacing the balustrades. It was actually somebody complaining that they weren't to standard. So James, what was your thoughts on this particular one? We'll flick it over to you.
Yeah, so in this case, the standard changed. So sometime about 10 or 15 years ago, the minimum height for a balcony changed from 900 mil to a metre.
Yep.
And there isn't any overriding obligation on an owners corporation to upgrade their common property just because there's a change in standard. There is, you all know, the general obligation on an owners corporation to maintain its common property and keep it in a state of good and serviceable repair. And that includes, if something wasn't right when it was built, making it right. In this case, it was compliant when it was built. The standard changed and there was an owner who wanted an upgrade done. The general law here is that the only obligation to upgrade your common property to current standards is if it's dangerous. And I guess the ironic part here is that the whole reason why the government changed the standard from 900 mil to a metre is because they thought that 900 mil
Wasn't
wasn't
safe.
sufficiently high to be
Yeah.
safe. So this
Yeah.
is a situation where it's probably harder for an owners corporation to
Mm.
say it shouldn't have to upgrade all balconies
Mm.
um, because the change in the standard was made for that purpose. Although I'm not aware, and Andrew, you can correct me on this, of there being a sudden influx of strata managers in New South Wales suddenly going to measure all the balustrades, check if
No,
they're safe, and get someone to go and do a report and tell them
correct.
if it's dangerous or not. So despite this case, that isn't what's happened.
Mm. Mm. Yeah. Yeah. So I guess moving on, and now this particular case, Safe Work New South Wales versus the Owners Corporation, there was a series. There's actually been Safe Work versus three separate entities, and we'll sort of delve into that in the following slides. Now, this particular one is going to be pretty much the headline or the focus of this webinar. So this particular case has sent shockwaves through the industry for a myriad of different reasons, but I'll let you explain this one, James.
So sure, this is a case where and I'll talk about this and the next slide together. So on 4 June 2020, a van travelling at high speed ran into an external perimeter gate. Well, there was an
Mm.
external perimeter fence around an 8-lot industrial complex that had 8 different owners. A van ran into the gate, did severe damage to the gate. That was on the 4th of June. On the next morning, I think it was about 9 o'clock at night. The next morning, various owners reported that problem to the strata manager. The strata manager issued 2 work orders. This is the 5th of June now. Issued 2 work
Mm.
orders. One, I think there was damage to the water meter or the water supply to the scheme, and the other was to fix and make safe, I guess, and replace probably that damaged gate. The strata manager issued the fixing the water work order as an urgent work order. I guess that those businesses couldn't function without water supply. So that was done same day. The water was fixed same day. The gate wasn't flagged at the time as an
Mm.
urgent work order. And a week later, so the accident happened on the 4th, the work orders issued on the 5th, and a week after that, on the 12th of June, there was an incident. So in the meantime, owners had been manually opening the gate at the start of the day and closing it at the end of the day. It had come out of its tracks a little bit. There were supports there that were higher than the gate to stop it falling over, but they'd been damaged as well. So people were manually moving it. And one morning, one gentleman went to open the gate at the start of the day. It was about 5:45 in the morning.
Mm.
He was the earliest person there regularly. He tried moving it. It got stuck. And one way or another, it ended up falling on him. It was a big, heavy gate. It took 15 minutes for anyone else to arrive. At about 6 o'clock, the next person arrived. A few people arrived. They got the gate off him, but it fatally crushed him. And so that's pretty much what happened in this
Mm.
case. That's the background for it. And we'll get into what the owners corporation, the committee's obligations were, and what submissions were put to the court, and what the court found in a second. So that's pretty much background. Is there anything you wanted to add, Andrew? Anything I've left out?
Yeah, yeah. Look, just on the screen is sort of the timeline that obviously you've just explained, James. I think the second point on the screen there, the initial attendance.
Oh,
So
that's
New
right.
South
Yeah.
Wales Emergency Services did secure the gate, but then basically thereafter there wasn't I guess adequate attempt to remove the gate, place it on the ground, make it safe. It was sort of strapped up, and obviously it was manually operated by the worker who basically was, yeah, obviously suffered the fatality. So I guess moving sort of on to obviously what could have been done, James.
Yeah, so what the argument, so it was a case between Safe Work New South Wales, which was prosecuting, no, and we'll get to it on the next slide, but it was prosecuting the lot owner who employed the person who died. It prosecuted the owners corporation for failing to take proper steps, and it prosecuted the strata manager personally as well. And the strata manager's professional indemnity insurance doesn't cover fines. So this was a serious matter for the strata manager as well. And what Safe Work New South Wales argued to the court was this. They said that the owners corporation or its strata manager failed to undertake an immediate risk assessment in relation to the safety and security issues at the site arising from that motor vehicle accident and the damage. Secondly, it failed to take the gate out of service immediately after the incident and post adequate signage to the effect that the gate wasn't to be operated manually. Thirdly, it failed to implement measures to keep people away from the damaged gate, such as temporary barricades and exclusion zones. Fourthly, it failed to direct that the damaged gate not be touched and it should remain open and unlocked so that people could go in and out. It might affect the security, but it helps the safety, obviously. And lastly, it failed to develop and implement a safe work methods statement or a safe work procedure for the manual operation of the gate if that was going to happen. And what the court found, it pretty much found all of that. It found there was no risk assessment done, no safe work method statement, no information or direction not to touch the gate. The gate should have been taken out of service, but it wasn't taken out of service. The strata manager had been given approval by the owners corporation and had issued a work order, but not an urgent one. And noted a few things to do with the strata manager, which is probably more an issue for the strata manager, that urgent work repairs were done to the water meter, but not the gate. That particular strata manager had only been there for 4 weeks. I'm not sure if they'd only been a strata manager for 4 weeks or only been at that job for 4 weeks. But they were managing 107 buildings at the time, which I think was significant. Wow. No one arranged an immediate risk assessment, and as I said, no one put proper signage around the area. So that's what was put to the court by Safe Work New South Wales, and it was pretty much all accepted and more, I'd say. And these are the prosecutions that happened. So the owners corporation was fined $300,000, discounted by 25% for I think an early plea and its contrition, etc. And it also was ordered to pay an agreed $40,000 towards Safe Works legal costs. The strata manager was similar, fined $200,000 for their failures. Reduced again by 25%. I'm not sure what the legal costs that they would have had to pay, but I'm guessing it was probably around $30,000. And the lot owner's business was the most severely penalised. The lot owner, interestingly, here was there were 8 lots in an industrial complex, and this particular lot owner was also the developer of the scheme and was found to know the scheme better and should have understood the issues better. And it was fined $500,000, reduced by 25% plus 44,000 in legal fees for pretty similar issues to what was found against the owners corporation, but a few extra ones because the person in question was their employee and they should have given better direction to their employee. And as I said, they were the developer of the scheme, and I think that added to their culpability as well.
Yeah. So I guess moving on, obviously part of the findings was that the 3 entities listed there, the owners corporation, the strata managing agent, and the commercial lot owner, were found to be PCBUs. So basically a PCBU, basically what it stands for, a person conducting a business or undertaking. So the definition here, a person conducting a business or undertaking, PCBU, is a broad term used throughout work health and safety legislation to describe all forms of modern working arrangements, which we commonly refer to as businesses. So obviously note this particular case involving Strata Plan 93899 case sort of set a precedent that a group titled structure, Strata Scheme, can be considered as a person conducting a business or undertaking. And James, my question to you, which I'm sure is going to come out on the Q&A if I don't ask it, is does that apply to all types of strata schemes? So this particular incident happened to an industrial site, so an 8-lot factory unit complex. Would it apply to a 6-lot villa complex or a 20-lot high, medium-rise development?
Look, so there's Section 20 of the Work Health and Safety Act, which places this liability and obligation on an owners corporation. Doesn't make that completely clear. In this case, the owners corporation, so there's an exemption where the the PCBU is the occupier of a residence, and no one's occupying the common property, and they're not really operating a business on the common property or giving an undertaking. But the important part here is that there's an exemption in regulation, clause 7 of the Work Health and Safety Regulations, and that says that where a strata scheme is partly or wholly used for non-residential purposes, where a strata scheme is used for non-residential purposes, it is not a PCBU for the purposes of this Act. However, there are a lot of cases where a completely residential scheme could still be deemed to be caught by these provisions about the PCBU. For example, where it's used partly or wholly for non-residential purposes, such as the loading dock being used for commercial purposes. The common property area is used for the parking of commercial vehicles. There's short-term letting, which tends to be considered a business use. And there might be short-term letting with a common property concierge desk, which is the common property being used for a commercial purpose. There might be a lease or license of common property for non-residential purposes like rock anchors and cranes and scaffolding. The exemption doesn't apply where the strata scheme, even if it's completely residential, if it employs someone. So if it's got, for example, a facilities manager for a large scheme and is paying PAYG and superannuation, then it's not exempt, even though it's residential. And the other issue is if you've got work from home impacts, people are actually not using it wholly for residential purposes, and they're using the common property for purposes that are linked to a business use. So even for a scheme that Andrew mentioned that's completely residential, there is still risk that it might be caught by those other things that make it fall outside the exemption for residential schemes. So it's certainly a bit of a grey area.
Mm. So I guess those strata committee members or owners corporations, if they do think that there's, certain aspects of the development which might lend them to be liable, then yeah, what should they do? Is it a matter of seeking legal advice?
Look, I think it's certainly better to be safe than sorry. And they can certainly get legal advice so that they know to be careful that they're not incurring any of these or make themselves liable because of any of these commercial types of use. And look, I think most residential schemes will probably remain a residential scheme for the purpose of this legislation and won't be caught for that. The work from home thing is a real worry because it'd be hard to find a building of more than 20 lots where someone isn't working from home for some of the time. I think that and normally when an owners corporation hires a building manager, for example, or facilities manager, it's normally under a contract as a contractor and not as an employee, but some of them might hire people as an employee. And look, the other thing is that we're putting together a bylaw that can apply to all schemes, whether they're residential or just want to be safe, that puts together a work health and safety policy. There were findings or there were comments made in the case about the processes that particular owners corporation has put in place since the accident, about what happens if there's an accident, who's responsible, who's instructing the strata manager, who's chasing the strata manager, who's doing what, how serious does it have to be, what do you need to instruct them to do, all those types of things you can put in a bylaw, which might be a bit different for each scheme, that help protect it from this type of thing where it can show that it's done everything possible. So there are a couple of things like that I think that we can do to help minimise risk for any owners corporation.
Thanks, James. Yeah, so who is a PCBU within this particular case? As we've already outlined, it was the owners corporation were found to be a PCBU, as was the strata managing agent and the lot owner, the business owner. So just to be clear, that lot owner, it's that individual's worker who was the one, obviously, who opened the gate and the gate fatally crushed them. So some sort of key points of what we're talking about here is obviously compliance is crucial to avoid significant legal and financial consequences. So And we will sort of expand, talking around, compliance and safety items around the scheme and give you some sort of tips and tricks when we progress in the slide pack here. Strata committees also must take an active role in managing safety, and we'll talk about that a little more. Acting on repairs and maintenance promptly is important. So you'll note the case that we brought to your attention. There wasn't a lot of time between the actual incident and the fatality. So you're talking, James, it wasn't even a week, was it?
Yeah, it was 8 days from the van crashing into the gate to the incident with the person, but it was 7 days after they issued the word, was sort of at night, so it was really only a week.
Really only a week. So yeah,
not a lot of
acting on
time.
repairs and maintenance is something that obviously this case was a reminder for the entire industry. When we had another scheme on the weekend that had a vehicle drive through an intercom system, and there's wires everywhere, and we'd obviously already trained that particular building manager, get the electrician out there, make safe, put signage up, alert everyone, and obviously it's a terrible case to hear about, but obviously brings to light the reminders that we should sort of be giving one another. Where repairs are delayed, obviously signage and communication are crucial. So, emails, text messages, before people come home, if there's an incident, we obviously have the setup to be able to do that through our software system, so we can assist in that regard, and also signage around the area. So I guess as Strata committee members, where you do notice an incident or something that is damaged that could potentially be a risk, obviously inform your Strata manager, give them a phone call, and obviously we'll obviously walk you through whether there is, the need to maybe put an urgent sign up, in the foyer or something like that, alerting everyone in the scheme to the issue. Implementing a WH&S policy can greatly reduce risks. So we will obviously talk about this a bit more. Now, how do you set up a policy for a strata scheme? Well, one suggestion that we have here is that could be executed by way of a bylaw outlining, the roles and the responsibilities of each party, etc. And obviously, as I said a moment ago, every scheme has the potential to be different. Some schemes, we might think, oh, look, nothing will ever happen here. But we do encourage you, ask questions. So ask your Strata manager if you have any sort of things that have popped in your mind that could be potential risks. And obviously, if we feel the need to, advise you to seek legal advice, and obviously, that can ensue as well. So obviously the nuts and the bolts of this particular case highlighted that there are penalties under WH&S legislation. So examples of the penalties up to 1.731.5 million, which is huge for breaches leading to serious risk or fatality. And the recent fines are the 3 that we've got on the screen there that we've already talked about. And obviously the impact of non-compliance is obviously legal costs, adverse impacts on the community, reputation, importance of obviously immediate risk assessment and hazard mitigation, super important. Now, a question that has come up on the chat, and we will just talk about that now. So I'm just trying to marry the questions up with the slides because I know obviously what's coming up. So let's talk insurance for strata committees. So one of the questions that has come into the chat is basically, can you insure against these sorts of incidents? And so, James, I might hand that over to you.
So there is office bearers liability insurance, as you as committee members would no doubt know. In this case, though, the insurance, the office bearers liability insurance covers a lot of things, but it doesn't cover fines. So just similarly to how the strata managers' professional indemnity insurance didn't cover the fine for them, then I don't think that strata committee insurance would cover a fine issued for non-compliance with the Work Health and Safety Act. I'd be very surprised if it did, especially in these days of insurance being more and more expensive and covering less and less things. So, and the other insurance thing, which I was going to mention later, actually, was that most owners corporations also have, as part of their insurance policy, legal defence cover. It only covers, usually you pay $1,000 excess, and it covers up to $50,000 of your legal fees when you are a respondent or defendant, not when you're starting the claim. But I've seen recently a few insurance companies deny insurance cover in a couple of situations. One of those is where the owner's corporation knew about an issue. In this case, it was a leak into someone's unit, and knew about it for several years, didn't do enough, and the legal proceedings ensued. And even though in this particular case that I was involved in, the claim failed because they were out of time to start it, the owner's corporation's legal costs of defending it weren't covered because the owner's corporation knew about the issue and didn't do enough, didn't do a sufficient amount of work early enough. And the other thing is that usually the insurer won't cover your legal costs unless you have reasonable prospects of winning. I've got one case where they've denied it for that reason, which is a bit ridiculous because the owner's corporation's Switzerland and a non-active party in it, but still not covering their legal fees, at least for now. So there's a couple of more reasons why owners corporations need to be very diligent in rectifying repairs. There's higher insurance premiums, which Andrew can talk about, I'm sure, a lot more than I can, for buildings that have outstanding defects, which you're required by law to report to your insurer. So there's a lot of ways you can save money on insurance by being diligent in exactly the sort of thing that we're talking about tonight in this main case.
So I guess that really takes us to this next slide around office bearers, legal liability insurance, and some examples of what it would cover. So some examples here: Strata Committee member instructs a painter to paint the building as per agreement at the AGM. The Strata Committee member is going on a holiday and instructs a Strata Manager to pay the painter upfront before the work is done. The painter disappears and the owner's corporation loses the money. Strata Committee member is held personally liable and sued by the owner's corporation. So that is an example of where the office bearers legal liability insurance may trigger. As James says, insurance companies, there might be fine print, and we're just speaking broadly there. All right, so before we sort of move on to guidance for the Strata Committees,
Sorry, Andrew, there were a couple of things I meant to say, if that's all right.
Sure.
If you don't mind me chiming in.
Yeah, go for it.
So the other two things, just two other specific pieces of legislation that if you don't know about, you should know about as committee members. There's Section 260 of the Strata Schemes Management Act, which is very important. That says that you as committee members are indemnified by the owner's corporation in respect of any loss, and I think that would include fines, as long as you're acting, and I'll just read it, as long as anything you do or fail to do was done in good faith. So if you were acting in good faith in the interests of the owner's corporation and you made a mistake, well, you're covered. If you're doing something known to be illegal or which might not be in the interest of the owner's corporation, or I'm sure there's lots of examples we could think of, then you might not be covered. So it's common sense, but to act in good faith in the best interest of the owner's corporation, just keep that in the back of your head. If you do that, then you at a personal level are safe. The other thing is Section 27 of the Work Health and Safety Act, which is a little bit scary, I've got to say. It says that not only do an owner's corporation who's a PCBU have the obligations under that act, but also it says Section 27 says if an owner's corporation, in your case, an owner's corporation has an obligation under the Work Health and Safety Act, then the officers of that owner's corporation, which in this case isn't just the committee members, it's the chairperson, secretary, and treasurer, must exercise, and I'll just read the wording, must exercise due diligence to ensure that that owner's corporation complies with their obligations. And some examples of what they need to do are to acquire and keep up-to-date knowledge of work health and safety matters, so training, to gain an understand of the nature of the operations of the owner's corporation and what hazards and risks are associated with it. So it might be that you need to hire someone to go and do that for you and rely on their report, to ensure that the owner's corporation has appropriate resources and processes available to it to minimise and eliminate those risks once they've been made aware to you. To ensure that the owner's corporation has proper processes in place for receiving and considering information about accidents and hazards and risks, and to ensure that the owner's corporation has and implements proper processes for complying with its obligations in relation to the business or undertaking that they're carrying out, and to check on those resources and processes as well. So there is an extra level of obligation on officers, not necessarily committee members, but officers, that you need to be aware of, and that again matters that we can give advice on if needed and include in bylaws, etc. The good thing about putting a bylaw in place, which Andrew mentioned, is that bylaws are easy to find. If you pass a resolution in the minutes of a general meeting, then 4 years later you have someone saying, "Remember 4 years ago, 3 4 years ago, can someone find that in the minutes?" Whereas with a bylaw, it's registered, it's on title, it's easy to find. Everyone is bound by it, by its nature of being a bylaw, and it's the most straightforward way of putting a process like this in place. Another example is legally, any owners corporation that has CCTV should probably have a privacy policy in place as well. And that, in that example as well, the best way to do that is by passing a privacy bylaw that talks about, in that case, how to record and store and release information that's been caught on the CCTV. So those are the two provisions relevant to this case, and one which is a general one that committee members definitely need to be made aware of.
Thanks, James. We just had a question there, and you sort of brushed over a little bit of the question. I just might ask you for a specific answer to this one. So Janelle asked, so would the individual committee members have to pay their fines, or would it be via a special levy for the entire owners corporation?
Well, it depends. Classic lawyer answer, I know, but if Section 260 of the Strata Schemes Management Act applies, and a committee member got fined despite the fact that they were acting in the best interests of the owners corporation. Now, the Strata Manager in this case was acting in the best interest of the owners corporation. They were just slow and could have done more, and that's what they were penalised for. So if the committee member is acting in good faith in the best interest of the owners corporation, I think that they'd be covered by Section 260, and the owners corporation would cover the fine. And that means, yes, if they didn't have enough funds available, they'd have to strike a special levy for it. I don't know of any exclusions where it's a fine or an issue under the Work Health and Safety Act. Section 260 should apply anyway.
Sure. All right. Another question here around lithium batteries. So anonymous attendee has a question here. So lithium batteries have caused fires in strata buildings. For safety reasons, should a strata scheme create a bylaw to restrict their use, define when and how these batteries should be charged, and how they should be disposed of within the scheme? Should this apply to a whole spectrum from EV to mobile phones? So interesting one. What's your view on that one, James?
Look, I haven't been asked about mobile phones, I've got to say, but in terms of e-bikes and e-scooters and e-chargers, installing them, using them, having lithium batteries on site, that is certainly a hot topic at the moment. And I'm probably asked at least fortnightly by owners corporations, what can we do about it? And can you put a bylaw in place that, with the Joe Cooper case, which was the one about banning dogs in the Horizon building in Darlinghurst. After that case, you've got to be very careful banning anything in an owners corporation, because there's a good chance that the bylaw, if challenged, will be struck down. You're better off putting very strict procedures around it. And it'd take a lot of lithium batteries and a lot of fires for, I think, the tribunal to uphold a banning bylaw. So what we do is we do other things. We put specific procedures in place about how you install, who can authorise the installation, what types of things can be charged and kept on premises. I mean, it might be that some schemes say, we accept your advice, James, that someone might challenge it and it might be overturned, but we want to put it in place anyway, because most people won't realise that. And we can tell them that the bylaw is there, and they might not realise they can challenge it. And even if they do challenge, they might not win. So some owners corporations take the advice and say, look, thank you for your advice, but we still want to go ahead, and that's fine as well. We can do that.
Yeah. Thank you, James. Might just throw a couple more questions out there. Is window lock inspection mandatory by law when the windows are not a common property? Usually the windows are common property. Now back in 2018, all strata schemes had to have their window child safety locks installed, where the fall on the on the outside of the window, I believe it was 2 meters, more than 2 meters, and the window on the inside was the window ledge was less than 1.7 meters in height. So there's that mandatory window lock installation law. However, there is no annual inspection law, but best practice is that you do get them checked. So I know there's a myriad of different companies out there that do that, to make sure that they're there. Owners corporations, obviously, you wouldn't want children, falling out a window for the sake of, a couple of dollars here and there to inspect that they're actually there. And haven't been removed. So there are also bylaws where you can pass those costs back to the lot owner who potentially removed, the window locks, etc. All right, just in the interest of time, we'll just sort of move on to the next little slice of the webinar tonight. So guidance for strata committee members. So moving on here, so ensuring safety on common property. So there's obviously duties under the WHS Act 2011. So strata committees are considered officers of the owners corporation with due diligence obligations under Section 27 of the Act. Now, we did have a question in the Q&A that talked around what if a strata committee member wasn't aware of an issue around the scheme. So I think that was Juliana posed that question. Good question there. I guess really, if you don't know about something, how do you action it? So I guess if, I'll give you an explanation. Actually, I managed a scheme many years ago in Western Sydney where basically a lady fell down the stairs. There was a tiled area, rain obviously fell on the tiled area and it was quite slippery. Now, basically, that was reported to me and as a strata manager at the time, and reported to the Strata Committee. And effectively, within, I think, about 48 hours, we actually had step treads put on the stairs and we had anti-slip solution sprayed on by a handyman, just to obviously mitigate the issue. Now, if we hadn't have done those steps, then, by all means, we could have been held, negligent should another incident of the same nature occur, but we acted on it. So the reason now that individual actually did file a claim with the insurers, and it was actually denied because nobody had ever raised that incident before. No one had ever said that the tiles were slippery. There was nothing in writing. There was no prior reports. It was the first incident of that nature. So I think there is sort of that, common sense approach that if you don't know anything about it, then, potentially you're not liable. I mean, there might be a different legal view from James on that one, but I think,
Well, all I was going to say, Andrew, was there's something called constructive knowledge. So it's usually actual knowledge, which you just mentioned, and constructive knowledge, which is where you should have known about it. Something was obvious enough that you should have known about it. So, and there's a reasonable test for that as well. So that was all I was going to add. Yeah.
Cool. Thanks, James. All right, so some key actions for compliance here. So obviously regular safety inspections and risk assessments. So we sort of form the view that, the safety inspections or work health and safety inspections tend to be mandatory for, industrial, retail, commercial schemes, not so mandatory for residential schemes. In fact, there are exemptions to have to do those safety reports. But as James said, sometimes there's a grey area, people working from home. I mean, the common areas of a scheme can be the workplace for obviously tradespeople, etc., that come to the building. Obviously, that's a separate issue there. But safety inspections generally would involve a qualified individual attending the site, working out if there's any risks around the common areas, highlighting them, bringing them to your attention, and obviously ensuring that you, as an owners corporation, remedy the issue. So adoption and implementation of a WHS policy specific to the strata scheme. Now, obviously, this particular case that we've highlighted this evening is fairly recent, and the judgments are fairly recent. We're actually in the process of getting a template bylaw sort of drafted up, obviously for all of our owners corporations consideration, with a suggested work health and safety policy within. So look out for that. Obviously, prompt reporting of issues noticed on the site probably goes without saying, but worthy of a mention. If you do notice anything, as I said before, at the beginning of the webinar, we do have our app where you can take a photo and send it straight through to the Strata Managing Agent. There was a question in the chat that said, if our agent doesn't respond, what do we do? By all means, escalate that up the chain. So, we certainly pride ourselves in having good customer service. And if you don't feel that an issue is being actioned, please, by all means, contact the office, ask to speak to the person's manager, and we'll obviously attend to that as soon as we possibly can. Prompt action on identified hazards, obviously including signage and access restrictions. So we talked around that. So again, the example of the gate being impacted, gate really should have been put on the ground or removed, not sort of strapped in place for over a week. And obviously prompt action on repairs and maintenance comes to the fore as well. So best practices, being proactive out there, conduct regular inspections, so scheduled periodic safety audits and engage experts when necessary. Immediate action on hazards, we've already talked about that. Clear communication, obviously informing all occupants of potential hazards and putting measures in place. And obviously legal and insurance considerations. So ensure adequate insurance coverage for legal defence costs related to work health and safety breaches. So note that obviously penalties cannot be insured against us. We've already talked around there. Implementing a WHS framework. So obviously developing a WHS policy should include obviously risk assessments, emergency procedures, clear roles for committee members, strata managers, etc. Obtain specialist advice. As I said, we're in the process of drafting up a template bylaw with a WHS policy in it. So WHS consultant or legal practitioner. So in this particular case, James has been given the task to draft up that template, and obviously we'll pop that on our upcoming agendas for AGMs, etc., for owners corporations to consider. Potential training and induction. So in preparation of this webinar, I reached out to a whole bunch of industry experts, so work health and safety experts, lawyers, you name it, I reached out to them. And I asked the question, would you provide regular training sessions for Strata Committee members or owners corporations so that they can induct, workers or obviously, be more active and identify risks? And pretty much everyone said, oh, we don't offer that service at the moment. So that's something, I put the word potential training there because obviously we're still out there looking for companies that would be willing to meet with owners corporations or Strata Committee members. As we said previously, every site has a potential to be different. So cookie cutter, one size fits all might not work in this particular case. Having some sort of training, is certainly worthwhile, and we're working on trying to find providers there. Monitoring and updating, so obviously continual review and update of safety procedures based on new risks or incidences. And sort of we'll just move on here. So I know we're sort of in the interest of time, don't have a lot of time left, so I'll try and keep this nice and concise. But other areas to focus on when we've got our safety hats on. So the first one here is fire safety inspections. So AS 1851, Australian Standard 1851, basically came out in 2012. And basically it set a standard for fire safety inspections. And effectively, at law, it is going to be mandatory from February 2025 to abide by that particular standard. So I'll explain a little bit more what that's about in a couple of slides' time. But we're also seeing that there is a critical point here of timely action of corrective action reports. So I'm going to explain what that is. But corrective action report is basically where your fire measures don't meet code or don't meet standard, and there's certain repairs that have to be effected. So let me get into a bit more detail about AS 1851-2012. So as I said, comes into effect in February 2025. Well, why is it some 13 years after the standard was basically brought out? Well, it has been a standard that many fire inspectors have adhered to, but it hasn't been mandatory. Now, it is now going to be mandatory at law by Feb 2025 for inspectors to essentially use that standard when they go and inspect a building. So previously, a fire inspector might go to the building and use their best efforts to deem whether a fire measure is appropriate or not. AS 1851-2012 implements a very, very rigorous checklist for every single type of fire measure. And effectively the contractors have to follow that in order to mark something off as being compliant. All right, so key notes for owners, corporations in strata property. So accredited fire safety system assessors. So part of this rollout is making sure the assessors know what they're doing and they're adequately trained and mandatory routine servicing requirements for owners, corporations in Class 1B to 9 buildings. And effectively, times are changing. So while most fire safety practitioners use AS 1851 as best practice, these requirements have not been enforceable until now. In fact, I was at an FPA, which is the Fire Protection Association Australia, a seminar last week with a whole bunch of fire technicians, and there was a question in the room about AS 1851 and what was it? And that came from a service technician. So a little bit scary out there, but they're doing their best, obviously, to bring that, or the FPA are trying to bring that back into line and ensure that everybody is adhering to that particular standard. So the main areas of which owners corporations should be aware of becoming mandatory are, and there's a couple of slides on this, so documentation and reporting. So the standard, as I said, has restructured, for want of a better term, the checklist that the inspectors would follow. Baseline data. So baseline data, it basically serves as a reference point or benchmark against which the condition and the performance of the fire protection system can be compared during future inspections and routine services. So in short, baseline data, an example is asset registers of fire assets in the building, the make, the model, the series, etc., of particular equipment in the building, how it's supposed to be maintained, etc. So that baseline data is easier to get for newer schemes. For older schemes, you could think 10, 20 years old. How are you going to get the original asset register of every single fire asset in the building? It can be very difficult. Sometimes we're reaching out to local councils to see what they've got on record. That one's proving to be a little bit difficult. Defect classification and non-conformance. So the standard distinguishes between critical defects. So an example of a critical defect would be a smoke alarm not working. A non-conformance or a non-critical defect might be, for example, a door tag. So a door tag or a frame tag indicates the fire rating of the door or the frame. That's probably not as important as, as I said, a smoke alarm. If a smoke alarm didn't work and there was a fire in an apartment, then yeah, there's obviously potential issues there. Routine service requirements. So obviously the routine service technical requirements have been critically appraised and refined under the standard, including changes in frequencies and application instructions, specific intervals for testing and preventative maintenance, and also precautions and defect rectification. So the standard highlights the procedure which needs to be followed in order to rectify identified defects. So what's ahead? AS 1851 comes into effect February 2025. Now, what we're sort of trying to prepare our owners corporations for is more rigorous testing. So we have been in the process for probably about the last 12 to 18 months of asking our fire service technicians to make sure that they're inspecting the building as if 1851 was mandatory, to make sure they're tested and inspected to a high level, obviously to ensure that they're safe. Now, what that might bring about is corrective action reports. So there might be items in the building, given the new AS 1851 inspection checklists, that potentially have not been highlighted before. So you may see corrective action reports being circulated. Some examples of defects that are coming up as a result of inspectors looking at buildings, I guess, a lot more thoroughly these days, given that 1851 is coming up. Is things, some defect examples are here that we've seen live in some of the buildings that we manage. So on the left-hand side, you've got a fire collar. It's present but missing wall extension. So basically, just to explain this is a ceiling space. So under AS 1851, basically the inspector is signing off that the entire building is built as per the baseline data and et cetera, et cetera. Now, in this particular example, there was an asset register and it was listed that there was a fire collar in the ceiling. And when the inspector went up into the ceiling of the apartment, he saw that the wall was incomplete. So basically what is supposed to happen, so let me explain this to you, is as you can see on the left here, there is a little bit of a wall. That wall, or Besser block wall, should go all the way to the slab. So on the left-hand side of that wall, or the little blue ring there, is one apartment, and where the photo is taking been taken from is a different apartment. So there should be a fire, like a wall between the two apartments in the ceiling space. And the job of the fire collar, or the little blue ring there, is basically to protect fire from obviously going through the wall. So it's made of generally intumescent material, so it expands under heat and effectively ensures that the fire doesn't sort of go through the wall. Now, in that example, there is no wall. So they've put the fire collar in, they've gone to that expense, but they've not finished off the wall. Another one here, there's a hole in a meter room wall. So you can see there that obviously a fire could go from one room to another. And here, no fire collars at all on the right-hand side there. A couple more defects we're finding. Here is an example of an exposed ceiling. So in this particular example, we're in a meter room and the cables and the wires that go up through the various levels, there's basically a gaping hole there. So if there was a fire in the meter room, which has the potential, obviously with electrical equipment being within that room, it could potentially send a fire all the way up through the building. Fire collars concreted over in that middle example there, and again on the right-hand side, another example of a wall gap. So as I said before, these are potential items that could be raised as inspectors are looking at buildings obviously more thoroughly to ensure that they are compliant. And in this example, that again they put the fire collar around the penetration in the wall, but there's a big gaping hole next to it. Other common fire defects that you might see, expired or defective smoke alarms, heat alarms, missing signage, emergency lights have failed. It might be missing block plans, and the block plans are very important. They tell the fire brigade the various zones in the building when they're looking at the fire indicator panel. There's a photo of one up there on the right-hand side. And here's some examples of how contractors are remedying those penetrations in the slab. So if there is big gaping holes in concrete walls or slabs, etc., there are available products that can obviously seal those holes and obviously have an inspector come back and sign off. So here's an example of some penetrations in a floor slab that were picked up by a passive defect report. And effectively some lagging around the pipes and a material on the bottom, which I have explained to some people, sort of looks like a Sara Lee cake, but I'm reliably informed it's not, so you can't eat it. Some other areas to focus on. So workplace health and safety inspections, as I said before, very common for industrial, retail, commercial schemes. A lot of residential schemes tend to opt out of it, but potentially given the cases we've been talking about this evening, it might be worthwhile having an expert have a look around the scheme. Now, it's one thing to get the inspection done. It's another thing to make sure the items are rectified. So generally, as you can see on the left-hand side on the little iPad there, here's an example of a page out of a WH&S safety inspection report. So what you'll see there is the item listed, an explanation of what potentially doesn't meet code. And in this particular example, there's items in a switch room. The second item listed on there is a gap between a concrete slab and a tiled surface, which could present a tripping hazard. And there's other items listed on there as well. So obviously the report identifies the risks and basically creates an obligation to repair. So a lot of schemes in the past have said, look, we don't want to get the reports because the potential is that if they come up with 50 things and obviously we've got to repair it. I say to that, well, better you have those risks identified and deal with them so that obviously you're not left in a position where you have injury or worst case death caused by that. So record keeping is also important. Something that we try to keep at a very, very high standard is when we have before and after photos is to make sure they're recorded on the system. We generally use that previous report like this particular one and there's a little date action column. We obviously fill that out once we've actioned the repair and take a photo, etc. Of the item. You can see in this particular one, the inspector raised that potential tripping hazard and suggested that it be painted with yellow. They like painting things yellow. And there's an example of a before and after photo from one of our reports. Next area to focus on, and obviously has been a highlight of the case that we have talked about, which is service and maintenance. So garage door maintenance and repairs. So, we can think of an incident where a vehicle hits a gate. Obviously that, presents a risk to address, but potentially things don't break. I mean, you can't really prevent a car from getting out of control and driving into the front of a building, but regular maintenance of items can obviously prevent incidents from occurring also. So obviously garage door maintenance, lift maintenance, which is generally negotiated and locked in. Things like access equipment, plumbing systems, and electrical. I've got a couple of photos here for you. So electrical systems, generally what is advisable here is your residual current device, your RCDs on your main meter boards, making sure that they work and that they are in place is a good suggestion there. Access equipment on the right there. So if you've got a taller building and you get your windows cleaned, obviously you're going to have some sort of access equipment to save you money hiring scaffolding. So it's important that those systems are checked and tested, and I believe the frequency is annually there. You've got your lift maintenance, obviously making sure that your building has adequate lift maintenance if you do have an elevator, and things like plumbing systems being checked and serviced, like pit and pumps in basements, etc., are obviously quite important to make sure that buildings don't flood. So if items like that are not serviced and buildings do flood, then obviously risks are presented, and there's more work for strata committees, owners, corporations, and strata managers, obviously trying to make good of a flood, etc. Often the cost of having these things serviced, are a fraction of what it could cost if a potential issue happens. All right, so I know that we're sort of at the end of our webinar tonight. I'll just have a quick look through the chat there and see if there's any sort of questions that we can close off here. I might bring James back into the conversation here, and I'll throw a question to you. This one says, loose mats in common corridor areas of a lift lobby, are they a fire hazard in the event of fire or evacuation? I guess you could sort of open that one broadly and say, trip hazards around a strata scheme. What do you think, James? Has there been many cases around those sorts of things on common property that potentially lot owners put in the common areas?
I'd say more of a trip hazard. I did actually have a matter where I was acting for a lot owner where they wanted to put a steel or mat, I'll call it, because there was from the basement up to the car park, up to the lift was a small rise. And their husband was in a wheelchair and thought it would be useful for people with wheelchairs and strollers, and they weren't allowed to. So, I mean, no owner can put their own thing on common property. Owners can't put mats on common property. They can't, outside their unit, have a little like a bookcase with trinkets or something. I've seen that as well. And is it a trip hazard? Maybe a fire hazard because it's a trip hazard, I guess. Yes, and again, and one of the questions that came through, I'm trying to think, one person asked a couple of times that about reporting safety issues. What if a committee member reports a safety issue and it's not actioned? It might have been one you were going to come to, Andrew, as well. Who is liable? Well, the committee member reports something and nothing's done. They should keep covering. They should keep chasing it up, so they're not liable. As we saw with the Strata Manager, they were held liable in that WH&S case for not issuing an urgent work order. And I might say with that WH&S case, when the fatality happened that day, they did get the gate removed same day. So it could have been done earlier if it was pushed. So if I'm a committee member, it's a thankless, unpaid job that you do. But keep pushing, and if that means pushing the strata manager, and as Andrew said, if you're not getting any satisfactory responses, then you've got to protect yourself and do what you have to do and take it up a line, then so be it. Hopefully you won't have to do that with the strata manager that you've got, but that's certainly what I'd recommend for you all.
We've got another question here that I'll throw to you, James. I've not heard of public liability insurance. Are members of the Strata Committee placed under this insurance when they become Strata Committee members?
I mean, certainly an owners corporation has public liability insurance. I think it's one of obviously they've got to have damage insurance. That's one of the
mandatory
main compulsory one. I think, I can't remember if compulsory, if public liability is optional or compulsory, but everyone would get it. If someone trips and breaks their leg or dies or falls off something in your scheme, you want it. You do have office bearers liability too for negligence and things that they do, as long as they're acting in good faith. But I don't know. I think it's one and the same, that if you've got public liability insurance for the owners corporation generally, I don't think anyone would bother suing a committee member there, unless a committee member had specifically told the strata manager, don't fix this safety issue outside John's place because I don't like John, so I want you to leave the trip hazard there. Maybe you'll fall over and it'll be funny. Okay, well, but you're not acting in good faith, obviously. But it's unusual. I don't know if I've seen public liability insurance that also covers committee members because I don't think they really need it there.
Yes. So yeah, there's a couple more here that we'll have a chat about. So legally, if a committee member reports a safety issue and it's not actioned, who is liable? So I think you've covered that one. Obviously, look after yourself, keep reporting it, and obviously, if need be, pass it up the chain. Obviously, we're yeah, noting that obviously this is a very important item to make sure that items are actioned very, very promptly. Another one here, really good question by anonymous attendee. To what extent do the building inspections conducted by NetStrata as a strata manager constitute a safety inspection for the purpose of work health and safety compliance? I can answer that one. So our inspections are not work health and safety inspections, and we do actually have a disclaimer on their reports. They're basically an inspection of the condition of the premises. So the purpose of it is to highlight things around the strata scheme, that we see could be important. So, for example, if the building needs to be repainted, or potentially the gardens are dying in a particular area that might not be accessible by the greater majority of the scheme, or looking at the condition of the what the contractors do, so the cleaning and the maintenance and that sort of thing. So often, we go to a scheme. We can check up on the cleaners' work or the gardener's work, etc., to make sure everything is up to standard. But they're not specific work health and safety inspections. We always recommend getting a qualified expert who's trained in that area to do that. That would obviously be an additional cost to the owners corporation, as we, as strata managers, are not trained in that particular area. But more than happy, to obtain quotes for schemes for those sorts of inspections. All right, I'll just have a look if there's any other final questions that we can throw out there. Here's an interesting one. Will there be a method to determine if the person is fit to be a committee member? What do you think of that one?
Well, I know there are changes to legislation proposed. I don't know if I put it quite in those words, but I think something along those lines that people have to. I mean, it's just been carte blanche up to now that anyone can be a committee member. But I think that might get a little bit tighter in the future. And Andrew mentioned potential obligations for training as well. So. I just remember in the back of my mind that there was something mentioned in the possible changes to legislation.
Yeah, it's mainly around training. So the little bits and pieces that I have been made aware of is that they're looking to insert a section in the Strata Schemes Management Act to make training mandatory for strata committee members. It does make a reference to the regulations defining the terms around that. But it does say that if committee members don't do the training, then they can basically be removed from being on the committee. Now, who does that training, whether it's industry associations or it's the government, or whether they allow private enterprise to do that, it's unclear at this point in time. But certainly those members that are logged on tonight obviously see the importance in training, and that's really positive, and looks like that's going to be sort of pushed out into the broader industry. All right. Any other questions there, James, that you'd like to answer?
Well, I did see one where someone said, is a bylaw effective before it's registered? That one I can certainly say the answer is no. It specifically says that in the Strata Schemes Management Act that no bylaw is effective until it's registered.
Yeah.
Someone else asked, I think that's the second time I've seen it, how does the obligation on balcony height obligations interact with heritage issues? I don't know the answer to that off the top of my head. And I don't know enough about planning law to be able to answer it, but I'm certainly not aware of any exemption for heritage items. I mean, there's heritage items and there's buildings in a heritage conservation area which aren't the same. I think if an owners corporation did receive a report that said your balcony height is unsafe and you need to do something about it, I guess the conservative answer is you'd then speak to council and say, look, we've been told we have to do this, we have to upgrade, and you'd have someone prepare proposals for balcony, about new balcony balustrades and put them to council to get approved, I guess is the answer. But that's, yeah, as I said, that's a conservative thing. I think even if they're heritage items, the balconies, you'd still have safety obligations regardless.
Correct. Yeah. All right. Well, thank you everybody for logging on this evening. Just a last little plug for the NetStrata app. If you haven't already downloaded that app, nice, quick and easy way to report issues around the scheme to us. Just want to thank James Moyer for attending our webinar tonight and giving us your time.
Thank you.
Yeah, really appreciate that. And hopefully everyone's enjoyed obviously hearing from our principal lawyer from Moyer's Law. Thank you everybody for logging on to the webinar. As I mentioned at the beginning, we will be sending around a recording to you of this webinar and also those in your strata committees that may not have been able to attend. They can obviously click on the link and have a watch of that. So thank you all, and we'll see you again next time. Thank you so much.
Thank you.